Hello, I'm David Jarrell, the leader of Bowen Gilfillan's Healthcare and Medical Schemes Law Practice Area. The question is often asked of us whether a medical scheme can refuse to pay a healthcare service provider directly for services rendered to a member of that medical scheme. And recently, the law has been a bit unclear in that regard, but on the 27th of April 2011, the Medical Schemes Appeal Board handed down a ruling which has luckily clarified that and should assist medical schemes and their members, as well as service providers going forward. The case that was involved was the matter of the Government Employees Medical Scheme versus Omphemetse Pharmacy. And briefly, the facts there were that the Omphemetse Pharmacy had been rendering claims in respect of pharmaceutical services for the scheme's members to the scheme electronically over a period of time. The scheme at a point in time had concerns around those claims and informed the pharmacy that it would be terminating direct payment to the pharmacy and would only pay members directly going forward, and that happened in May 2008. Despite that warning and that termination of the arrangement at that point in time, the pharmacy continued to effectively run up a tab on behalf of its customers who happened to be members of the scheme, and eventually claimed against the scheme for payment of that tab, which ran into more than R1 million. The scheme objected, and the Registrar of Medical Schemes agreed with the scheme that it had no obligation to pay the service provider as opposed to its members directly. And then the pharmacy went on appeal to the Appeal Committee for the Council for Medical Schemes. That committee actually ruled against the scheme. The committee held it declared that the scheme had not complied with Section 59(2) of the Medical Schemes Act and directed the scheme to make payment to the pharmacy in respect of the claims that it had run up in relation to the members of the scheme. This ruling was made even though the scheme had already paid the members directly, so the scheme was clearly faced with a situation where it could end up with a double liability and the obligation to recover its funds somehow. Faced with this situation, the scheme approached the Medical Schemes Appeal Board, and that board ruled, as I said, on the 27th of April 2011 in favour of the scheme, but the content of that ruling is very important and can be found on the Medical Schemes, the Council for Medical Schemes website. In short, I wanted to explain to you what the Council ruled, as it does have quite significant implications for medical schemes, for medical scheme members, for healthcare service providers, and other stakeholders in the industry. The main issue that the Medical Schemes Appeal Board identified was what right a supplier of services has to the member of medical scheme to claim payment directly from the scheme in the absence of a contractual relationship with the scheme. Now, the Appeal Board proceeded to analyze what the business of a medical scheme is, and that clearly is the business of defraying expenditure of members on behalf of members in return for a premium received from members. And the Appeal Board said that this indicates that the business of a medical scheme is very much akin or like the business of a short-term insurer. And because there was no contractual nexus between the scheme and the service provider in this case, the Appeal Board ruled that it wasn't appropriate for the service provider to sue the scheme directly for the amounts that became owing to the service provider by virtue of it having supplied pharmaceutical services to the members. All that the business of a medical scheme entailed for this legal relationship was that the member would be able to claim against the scheme to insist that the scheme reimburse the member. The service provider would never have a direct claim against the scheme in terms of the Medical Schemes Act. At best, a service provider, and this would be advice to service providers, would be in a position to hopefully going forward negotiate a contractual relationship with the scheme in terms of which the scheme undertook liability to pay the